welcome everyone this morning on March 1st, 2021. Okay, and I would like to introduce our chair committee from OPA. He's going to speak on behalf of the Ontario Paralegal Association, Doug Taylor. Doug Taylor, welcome. And please do the opening remarks for all of us.
Thank you, Leo. Appreciate that introduction. Welcome, everybody. We're very excited to be participating in this event, coordinating with Trials College. It's something brand new for OPA. And Leo is a student member of the Ontario Paralegal Association. For those that are not members and interested to learn more, you can visit opaonline.ca. I'm joined by a couple of my colleagues on this CPD as well. The student director will put his information in the chat, so you can feel free to reach out to him if you have any questions as well. And the vice chair of the education committee, April Dark, is also on this call, and she is also in the chat window, so both are available to reach out to them. This is something brand new for us, and as usual, technology is a wonderful thing. We're having some challenges, but rest assured, the panel is here, and we're excited and ready to go. This is a typical support that OPA does provide to all their members. It's something that we strongly believe in. Student membership for us is very core to what we do at the Ontario Paralegal Association, and we take any opportunity to reach out and support students in the community. And I'd like to extend my thank you both to Lori, Leo, and Ted, and Trials College, and the rest of the panelists for joining us today. Thank you, and enjoy.
Well, thank you for those opening remarks, Doug. So we have our next order of business, Lori. She will do our opening remarks about Trials College and this important event. Thank you, Lori, for joining us today.
Perfect. Thanks, Leo. Yes, we can all relate to technical problems, so we have gained patience for that for sure. So I would like to welcome everyone to the Criminal Law Matters. I'm Lori Fast. I'm the campus director at the Trios Kitchener campus. On behalf of Trios, I would like to thank all the panelists today for their time and dedication to educate our students. I am confident that we will be able to provide an introductory knowledge of what our students will need in criminal law. I'd like to thank the Ontario Paralegal Association as well, their president, George Brown, to the educational committee members for jointly organizing this event with our program coordinator, Ted Claxton, and our student, Leo Rodriguez. I hope all students will enjoy this kind of leadership and contribute to their profession in meaningful ways. I also encourage our students to join the Ontario Paralegal Association as members. Trios College recognizes that we need leadership among all of our students, and we enhance their learning with these events. I hope everyone enjoys this virtual experience, and on behalf of Trios College, we are excited to get this event started. Thank you.
Thank you, Lori. That was an amazing opening. And I will introduce our next order of business, which is Doug Taylor. Doug, you will introduce Sahida, please. I guess Doug is busy right now. Let me introduce Sahida Bowen. Sahida Bowen will be our moderator today. She's an amazing aide, and she will also introduce our original land recognition test. And I hope you all will enjoy this experience with Sahida as well. And welcome, Sahida.
Thank you so much. Thank you so much. Good morning, everybody. We just wanted to take a moment to do the Aboriginal land recognition. Long before today, there have been Indigenous people who have been the stewards of this place. As we gather here, we acknowledge in particular that this is the traditional territory of the Anishinaabe, the Haudenosaunee, Shawnee, and the neutral people. We recognize and deeply appreciate the historic connection to this place. Thank you.
Thank you, Saida. So, as a host, I'm going to introduce our panelists today. Each of them have contributed to the criminal law field. Each of them have given their views in the courtroom, and each of them will support this event in meaningful ways. I'm Leoncio Rodriguez. I'll be your host. I'm a trials student myself in the paralegal program. And I can tell you that this is an introductory event that will give you an insightful knowledge for the future of your professions in whether it's in the criminal field or just dealing with a minor offenses. Again, thank you so much. And I'm going to introduce our first panelist of the day. First order of business, Mr. Aristides Ciuffetelli. Welcome. We're happy to have you here. And just to give you an introduction about Mr. Aristides Ciuffetelli, he has an MA in philosophy and law. He's the main professor of Colombian defense public defenders, and he has been a judge in specialized tribunals in criminal matters. He has been also a professor at Caldas University in law and criminal law. It's an honor to have you here today, Aristides. Can you please explain to us who you are? Can you explain as the role of a judge as a whole? Can you explain as guilty pleas? Can you explain as pretrial issues? And can you let the audience know what you have done in the past? And welcome to this criminal law matters event.
Empiezas. Good morning to all. Thank you very much for the panelists and the person who are present here today. I'd like to thank every one of you to invite me to this specific event. I'm here to share my expertise on the science that I practice. I would like to thank the Ontario Paralegal Association and Jurist College, as well as Leoncio Rodriguez for the invitation and Alexander Rea as a math translator, and of course, the students who are here with us today. Once again, thank you for the translator, Alexander Rea. Yes, the new accusatory system in Colombia has a very specific movement of the judges. So we're going to spend this start introduction by showing the steps of that process. We have 4 stages on the process of we call investigation process, imputation of charges, preliminary hearings, trial, and of course at the end, sentence. We do have accusatory system that has 2 kinds of judges. The one that is a judge of warranties, who takes steps of necessary to detain defendants and preserve evidence and protect the community. And the other one is the judge of knowledge, which is in charge of the trial following the new accusatory systems of Colombia's constitution. So we have two judges. The first one is called Judge of Warranties or Juez de Garantías, which takes the necessary steps to detain again the defendants, preserve evidence, and protect the community, and has the moment to ask the defendant if he accepts or doesn't accept the charges. So sometimes when he accepts the charges, which is on the reference plea bargain, he probably get half of the sentence at the end of the process. So sometimes the accuser has the possibility of being, there are some matters where we have to ask the defendant that the accused, I'm sorry, that he has the right to, I'm sorry, I missed that part. Aristides, repíteme ese pedazo. Okay, he's saying that in the case that this accused has violated a child, which is a situation complicated, terrorism or humanity inquiries that attend to people, he has no right to that 50% of exclusion of the penalty. So in some cases, we call that kind of justice premial, which is we give an award of the person who gives information or plead guilty or plea bargain at the beginning. So the first thing that we already said is that the judge of guarantees is in charge of the necessary steps to detain the defendants, preserve the evidence, and protect the community. But at the same time, when the next judge, which is the judge of knowledge or el juez de garantías, he is in charge of the trial. And then there's three steps that are going to follow. So the three steps that the judge of knowledge have to follow in the trial are the imputation of charges, preliminary hearings, and the trial. So in the, go ahead. So on the first stage that the judge of knowledge has to follow is the imputation of the charges, which are like preliminary hearings, where he has to follow the imputation charges. When we're talking about preliminary hearings, the fiscal, which is the, in that case, in charge of doing the accusation process, has the time as well as the the preliminary hearing. Hold it. So the preliminary hearings, no, hold it. Espérame. Entonces, the preliminary hearings is on charge of the fiscal for one side, and the other side is the counselor who is in charge of bringing the evidence of the future trial. So in disciplinary hearings, is there's the evidence is the only place where the evidence has to be part of it. If after that, there is no place for that. So the plenary hearings have to have the quality that the evidence has to be contundent, evident, and real. So the DA and the counselor, they have to bring all the proofs before the trial. Before in the trial, there were no space for do it. So it's only the judge who has the opportunity to ask for new evidence to the case. So in the trial is the moment when the judge has the opportunity to say the sentence to the audience. So maybe a sentence that maybe put the accused free or put on jail.
Aristides, we have a question
Aristides, tenemos una pregunta.
From the audience. When given a sentence, what do you consider based on the accused, based on the case? What do you consider when giving a verdict?
Cuando estás haciendo eso, ¿qué tipo de sentencia es la que se hace? ¿Qué tienen en cuenta para el desarrollo de la sentencia, Aristides? Pregunta Leo. Yeah. It's only because of the proof, Leo. It's because of the proof, and the judge has the authority to ask if he's able to interpret that situation for the good of the accused. Here in Colombia, we don't have the jury, the juez de conciencia, which is like following the United States jury. Is only the judge who takes the last decision in these cases. So we're doing what is needed in this case is he has to be, in the case of the judge, he has the specialty of dogmatic and interpretation of the law. we can never forget that he is innocent in the case of the accused until proof contrary.
Alex,
Yes.
is there a possibility that Aristides can mute himself, please?
Yes. Aristides, tienes que hablar solo, sin traductor.
On Zoom, he's muted. Can he unmute himself? We appreciate if he could mute himself from Zoom. In the meantime, I truly apologize for this delay. Mr. Aristides is using a translator, and that's why there is a delay. We're trying to mute Mr. Aristides, so please bear with us.
Ahí, ¿me escuchan? ¿Me escuchan?
Yes,
Sí.
we can hear you now. Thank you so much.
La sentencia puede ser con condena intramural, o sea, en un centro penitenciario. Si la condena no supera ciertos topes en su dosimetría, pueden concederle una prisión domiciliaria cuando no es muy gravoso el delito, o una condena de ejecución condicional. ¿Continúo?
Alex.
Alex.
Yeah, got it. So sometimes the judge has the opportunity on the trial to put an absolution if there is no proof, or at the same time there is an audience, there is a change on the final sentence, which is next to the accord with the Fiscalía and accord with the Defensoría to the final absolution of the sentence.
So that would be the Crown and
In your terms.
Canadian system, and another organism that will only be applicable in Colombia, correct?
Yes, that's right.
Quería terminar manifestándoles
I would like to tell you at the end
que en Colombia, cuando un acusado no tiene capacidad económica para sufragar los honorarios de un abogado, el Estado le designa a través de la Defensoría Pública un defensor público para que asuma la defensa desde la imputación hasta el juicio, sin cobrarle un solo peso. ¿Continúo? Leo.
Okay. All right. Alex, could you please translate that?
sometimes when the defendant has money to pay for a counselor, the state of Colombia has the right to help it with one, with no cost.
Yo quisiera terminar además manifestando que no es lo mismo, en mi criterio, tener un abogado de confianza que no tiene tanto volumen de trabajos como los defensores públicos y que conlleva que cuando el defensor es privado pueda dedicarse con más dedicación a las defensas. porque los defensores públicos llevan muchos casos que los absorben y la defensa puede que sea buena, pero creo yo que falta un poco ahí de defensa técnica por ese volumen de trabajo.
I have a final statement. I know that the defendant has the opportunity to ask the state of Colombia to provide a defendant, but sometimes the public defendant have too much work to do. So it's better that find a private one which has the confidence to keep the work of the trial until the end.
Para terminar, quiero manifestarles que de todas formas en nuestro país los jueces son unos héroes, dado que les toca llevar casos muy delicados, lo mismo que los defensores públicos que a través de su volumen de trabajo también llevan un sinnúmero de casos que los absorben y que a pesar de todas nuestras falacias, hay algo que aún respetamos, que es la dignidad de la justicia, y a los defensores que asumen con esa vocación las defensas del acusado, que es el personaje principal del proceso penal, al cual se le trata o se busca de todas las maneras que se le respeten los derechos humanos. Muchas gracias a todos.
Alexander, could you please unmute yourself, please? Thank you.
Yeah, I would like to say finally that the Colombian judges, there are heroes. In our regular situation, they almost get killed or sometimes they get out of the country. As well, I would like to say to the public counselors, they work as hard as they can. And I would like to say finally as well that the defendants, they have the opportunity to defend themselves with the justice that we're trying. We're not perfect as a country, but we're trying to do our best in following this new accusatory system in the Colombian Constitution. Thank you.
I'm glad to have you in our panel, Aristides, and thank you for sharing those experiences. At the end, if any of the attendees have some questions for Mr. Aristides, we'll be able to take them. For now, if that's okay, we're going to introduce our next panelist. She's the crown in the Waterloo region. She has taken the initiative to be part of our panel, and she has taken part of crime prevention in the region in different committees. And I'm glad to have her here today. Her name is Patricia Moore. Patricia, I'm glad to have you in our panel today. And I know your time is precious. Can you give us an overview of our criminal system and how it works from your point of view as the Crown? Please go ahead.
Thanks, Leo. Thank you for inviting me today. I prepared a PowerPoint to get through some of this material. I'm going to try to keep it fairly high level. I know that this is an introduction to your next session on criminal law. So I am the Crown Attorney for the Region Waterloo. We have about 27 assistant Crown Attorneys and 14 business professionals that work at the Crown's office, which is located in the courthouse. I always like to just start my presentations with a joke, so everybody can just take a second to read that if they want. And we'll move on to the next slide. All right, so I just wanted to talk about the role of the Crown. And some people are confused and they sometimes will say, oh, you're representing the victim is your client and or something like that. And that's not the role of the Crown. The Crowns, all Crowns and assistant Crown attorneys are actually agents of the Attorney General. And way back in 1955, Justice Rand, in a Supreme Court of Canada decision of Boucher, had this to say about the role of the Crown. And I'll just read it briefly. It says, it cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly. The role of prosecutor excludes any notion of winning or losing. His function, her function, is a matter of public duty, that which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings. So that is the role of the Crown. We are often referred to, in addition, as ministers of justice, that we have an obligation of objectivity and independence and fairness. That doesn't mean we can't be passionate, but we have to ensure that that passion is tempered and that we maintain our role as Crown attorneys and ministers of justice. Next slide, please.
Police, hacks, different roles.
Leo, next slide.
The Crown have different roles.
Oh, thanks. Sorry, it's not, for some reason it's not. Oh, there we go. Yeah, so I just wanted to touch briefly on the roles of the Crown and the police and emphasize that we have different roles. Many courts have said we have to remain separate from the police. The Crown and the police often consult each other, and that's not only permissible, it's encouraged. And but we have distinct functions. The decision to charge is within the sole discretion of the police. And sometimes you'll say, oh, the Crown, we may ask the police to consider alternate charges, but at the end of the day, it's up to them whether or not they in fact lay those charges. And the decision to prosecute is solely within the authority of the Crown. So once the charge is laid, the police can't say, don't have power as to what happened to it, in the sense of that's up to the Crown to decide. I often talk about the three standards. The police lay a charge on reasonable grounds to believe that a crime has happened. The Crown's test proceeds only if there's a reasonable prospect of conviction and if it's in the public interest, and the judge can only convict if the case is proven beyond a reasonable doubt. Next slide.
Go ahead.
I didn't even know I did this fancy coming in thing. So the Crown Prosecution Manual, although also known as the Crown Book or the Crown Bible, is actually available online, almost all parts of it. There are some confidential directives, but the Crown Prosecution Manual itself is available to anyone and everyone who's interested. And it is our instruction manual. So if you want to know about what a Crown should or must do in certain situations, then I would suggest taking a look at the Crown Prosecution Manual, because that is where we take our directive from. Bail is an important component, first step. If someone gets charged with a crime, they're either released by the police, and a recent bill gave the police some enhanced release powers and encouraged them to release from without holding for bail. But if they're held for bail, I won't read it, but that's the direction right out of the Crown Prosecution Manual, that we are to consider the least restrictive form of release and not request a surety unless all other forms of release have been considered. But if we believe that the release of the accused would jeopardize the safety of the public or of a victim, and that risk can't be mitigated by appropriate terms and conditions, then we must seek that person's detention. I think people will often hear about the case of Stinchcombe. It's under disclosure, and that is a quote right from Regina and Stinchcombe. And so that's been a law since 1991. And it indicates that the Crown has a legal duty to disclose all relevant information to the defense, also called the fruits of the investigation. which are in the possession of the Crown. Either we're using it to secure a conviction, or it can be used by the defense. It's subject to the discretion as to timing and as to rules of privilege. We have to exercise that discretion carefully. It can be reviewed by a judge on a motion for disclosure, application for disclosure. The test is that we must disclose unless it's clearly irrelevant or it's protected by privilege. The defense does not have a duty to disclose its case. There are some exceptions under the sexual assault provisions. So some places in the world have dual disclosure obligations, but Canada does not. So what happens when it comes in, a file comes into the Crown's office? It has to be go through the screening and vetting process. So each file received by the Crown after the police lay charges is vetted. So the police do an initial vetting. They'll put a box in Adobe around personal information, and we will check that, and we will also add any other boxes. So we vet out personal information and any information that could be privileged, solicitor-client privilege, confidential informant privilege, things of that nature. In our office, that vetting and screening is done at first instance by our business professionals, or our CMCs, which are case management coordinators. We have 3 of those, and they're all paralegals, and they perform a very important role in our office. It's then reviewed by the Crown. Each file is also screened. Screening means an assessment of the evidence to decide whether we meet that standard, whether we have a reasonable prospect of conviction, and whether it's in the public interest. So we don't get to the public interest question, and we have to pass the RPC hurdle first. So it's important that they go in order, but even if something has a reasonable prospect of conviction, the Crown might decide it's not in the public interest to proceed because it's too minor, or for a variety of other reasons. You'll hear that sometimes on the record. Crown wants to withdraw a charge for no reasonable prospect of conviction, or the Crown isn't proceeding because it's not in the public interest. So that is a part of the role of the Crown. If it does proceed, we must decide if there's other charges that should be laid, or if other evidence needs to be gathered. If we determine that, then a screening request is sent to the police to provide that further information. The next thing the Crown has to decide at this stage is the election, summarily or by indictment. And that's important, obviously, for the paralegals, because you're only allowed to appear on certain types of offenses. And the Crown must also determine its position on sentence on an early plea. We also determine at the stage if it's going to be diverted. So we have a lot of offenses, class 1 offenses were called, theft and things of that nature, that get screened for diversion, which means it goes to Part 3 POA prosecutions at court. Well, somebody's not on mute. That's okay. So note about plea negotiations. So I just want everybody to look at this screen. I have circled a couple of things on it. So in Kitchener-Waterloo, I just did up to 2019 because 2020 with COVID was a little off. But look at that number, 95%. That's the number that's the percentage of cases that are received by our office that are resolved before trial. So a lot of people talk about trial skills and abilities, and those are important because that is sometimes what leads to this number. But 95% of all of our charges are resolved pre-trial. So I think that gives everyone a sense of how important plea negotiations are and how essential they are to the process. Sometimes people talk about plea bargaining as a bad thing, but if we didn't have plea bargaining, our system would literally collapse because even when we are only dealing with 5% of matters going to trial, we still have delays. There's a case called Jordan that gives timelines for when things are supposed to get to trial. So that's considering only 5% of the matters that are laid go to trial. So this is a really important piece of information, I think, for people to understand that most of our charges never get to trial. They are dealt with either through diversion, through withdrawal, or through some form of plea negotiation. And how do plea negotiations, I didn't do a slide, but how do plea negotiations happen both in criminal and in POA? Well, there's a Crown pretrial, which means a meeting between the Crown attorney and the defense lawyer or the agent for the defense. And at that pretrial, you discuss trial issues, timing, motions, things of that. But you also discuss plea negotiations, which offenses you want, what position the Crown's going to take. So for criminal matters, you'll have seen the screening form, which will have an initial position on it, but you may want to try to talk the Crown away from that position, or at least discuss the charges. If things are not resolved at that stage, then they go to the next stage, which is a JPT, or a judicial pretrial. And that's a meeting between the counsel and the judge, or the judge and the Crown and the self-represented individual. If for self-represented judicial pretrials, those are done on the record. For pretrials that are between counsel or between agents, those are not done on the record. Those are generally done now on the phone, although we're talking about moving to a Zoom platform for those. So that's why plea negotiations are so essential to the proper working of our system. But if you do get to trial, a few pointers. Don't underestimate the value of pretrial motions. Many cases are actually determined at the pretrial motions stage. I think Leo said I've done some major cases, murders, multiple murders, sex assaults, things of that nature. Sometimes the case is decided if at the pretrial stage, if important pieces of evidence are excluded, or if important pieces of evidence, like say a confession of an accused, are included. That may lead to either a plea, or it may lead to plea negotiations in favor of the accused. So those are a really important stage of the trial, or the pretrial motions. I'm sure everyone will be hearing quite a bit about the Charter of Rights and Freedoms, but it has played and will continue to play an important role in our criminal trials. At the trial, the Crown examines the witness in chief, which means we cannot ask leading questions or suggest the answer to questions. And that's in contrast with cross-examination, where counsel can very much suggest an answer to a witness or ask leading questions. I suggest that the car was blue, where in chief, I would say, what color was the car? So there's a difference in the manner of asking questions. At trial, there's usually an order excluding witness, and that's to prevent tainting. Human nature, if you hear what someone else says, and it sometimes does become mixed with your own memory. So even if people aren't trying to intentionally absorb other evidence and are trying to tell the truth, if you've heard a version of events from other people or multiple other people, sometimes that version of events becomes incorporated into your memory of the event. So we try our best to prevent tainting of witnesses. The investigating officer, I put IO there, often assists the Crown by taking notes, helping with exhibits, and sometimes suggesting questions. Closing submissions. At a trial, the defense gives their closing submissions first, except, and this is a rule, except if they've called no evidence. So if a defense has not called any witnesses, then they are entitled to go last. So it kind of changes up depending on if the defense has or has not called evidence. This is your last chance to persuade the judge of your position. And don't oversell your case. Admit your weaknesses and explain how these are overcome. Because at the end of the day, what's persuasive is if the judge can trust you. Are you telling the truth? Are you representing facts fairly? Are you representing the law fairly? Because if you lose credibility before a judge, then you have probably lost your case. And if there's a conviction, sentencing. Given the 95% resolution rate and convictions after trial, sentencing submissions make up the biggest part of what we do. Decide whether you want to arrive at a joint position. That means a position that you and the Crown will suggest together to the judge, or go in open, which means the Crown will ask you for something and you will ask for something different. And there are different considerations. Won't want to get into the details here, but I'm happy to answer any questions. Have a clear list of the aggravating and mitigating factors on sentencing. The Crown always does that, but I suggest the defense does that as well. Obviously, if you're defending someone, make sure that you can add to those mitigating factors and explain those mitigating factors and how that they should be impact on the sentence. I find most judges prefer point first submissions. So instead of getting to what your position is 5 or 10 minutes into your submissions, then I would suggest that you get to it and let the judge know what you're asking for, and then justify or explain why you're taking that position. Also, ensure you know what ancillary orders may apply and the details, including, are they mandatory, are they discretionary, how long are they for? And some of the mandatory orders that you'll find in criminal law are weapons prohibition, is section 109 orders, section 110 orders. One's mandatory, one's discretionary. They can be for 10 years, they can be for life. SWARA, sex offender registry. Again, it says different requirements depending on circumstances. DNA, is it primary, compulsory, is it secondary? 161 order, which is telling people they have to stay away from school grounds and community centers and things like that. So these are really important. And if you're appearing in court, the judges are going to expect you to have considered what ancillary orders you're seeking, or the Crown seeking, and you know, to know your stuff. So don't forget the ancillary orders. And that's it.
Our next panelist will be the Defense Counsel. His name is Ted Claxton. He is the program coordinator at the Kitchener campus and also for London and Hamilton. He has been a Crown attorney, well, not a Crown attorney, a defense counsel for a couple of years in criminal law. He has defended different types of cases. And we're glad to have Ted in our panel today. Welcome, Ted. And please give us an overview of what the Defense Counsel does and what's the role in criminal law of the Defense Counsel.
Well, hello, everyone. Maybe we put his honor first, but technical difficulties. He's going to be having the cleanup role here, so that's good. Anyway, an opening note and something that Patricia made clear, and that is your reputation. Your reputation follows you wherever you go. Counsel and judges talk. Everyone is watching and listening to you at all times. There's a lawyer who's got a rather peculiar name behind his back. His name is Toothbrush. That's because this person is unrealistic in what he's doing. And people go to jail when this lawyer has told them, oh, it'll be a probation or this or that. The next thing is this. There are only 3 things that you need in order to succeed. The first one is preparation. The second one is preparation. And the third one is preparation. And if you follow those 3 rules, you will have success. As our Crown Attorney, Patricia, pointed out, the Crown's not there to get a conviction. They have success, whether the person gets a diversion or gets acquitted or gets convicted. That's what you're working toward, that you've done everything that you can in relation to the case. So what is the role of defense counsel? What I learned at law school was that the idea is to raise a reasonable doubt. And when you raise a reasonable doubt, then your client will be found not guilty. And if you can't do that, well, then you better think about guilty pleas and what's going to happen to the client. However, what I learned from Mr. Michael Neville, who was my principal, and Mr. Donald Bain, who was his friend. I sort of got linked to Donald Bain once in a while to cover things for him. And that is, you should prove the defense beyond a reasonable doubt. Then, if you prove the defense beyond a reasonable doubt, there's no problem with getting over the hurdle of reasonable doubt. Next, client confidentiality. The scales are on one side. The Crown has to disclose everything that they've got, except for the exceptions that Patricia mentioned. As far as being a defense counsel, you don't want to say anything to anybody at any time. There's usually not public interest issues in the criminal law. You often see lawyers out there, somebody's got the microphone in front of them. I never had the microphone in front of me at any time while I was doing criminal law. I had a prominent figure in the community who was charged with a sexual offense. These are no longer criminal offenses, but they were then. And the police had a big crackdown, and over 25 people were charged. And they all appeared, of course, on the same docket because the police wanted to keep all these cases together, so they gave them all the same date. And of course, it was a big deal. There's a newspaper reporter sitting in there and the TV people outside. Well, my client, I went and said, you just go and sit over in a corner and don't let anybody see who you are or what you're doing. And I went to my friend, the Crown, and I said, look, I got a motion down in Superior Court. Can we put this over to the afternoon? Sure enough, no problem. We did that. I came back and I sat in the afternoon after 2 o'clock in the back of the court. The Crown had a long list that day, and it was nearly 4:30 before we got finished. I got up. I waived the reading of the charge. I waived the preliminary hearing and had it go directly to a Superior Court judge. And then I went to the Crown's office and we organized a date for a plea. And that plea was done on an afternoon on Friday when nobody was in the courthouse. And the plea was entered and the judge, I made my pitch, and the judge was very lenient in that plea. There was a very well-respected person, Eugene McCarthy. He was the crime reporter here and even wrote a book about some big crime. I forget what the title of it is. He called me up. He must have got wind that this person wasn't on the regular list of the over 25 people. So he called me up and said, oh, what about this person? Are you representing that person? It is a matter of client confidentiality. They are representing anyone. You cannot tell anybody, yes, I'm representing that person, unless you've got the permission of your client. As I said, nobody showed up on that Friday afternoon. There was myself, the Crown, the judge, and the accused. That was it. On the pre-trial issues, of course, we have, I think in Canada, a very good system. When you see what happens to poor people in the United States who get cash bails, we got rid of the bail bondsmen back in the 60s. They got tossed out because we made the system, basically you get out unless there's a real good reason why you should be held in. So, but sometimes the clients aren't always in tune with what your advice is. I had one on a Friday afternoon, a second offense, so it was a reverse onus situation. The Crown was very reasonable, said a surety comes forward, we'll be okay with that. Well, the person wanted to get out. He told me, I've got to go to a party. I want you to deal with the bail hearing this afternoon. I said, no, you're going to be held in. It's a reverse onus situation. When the person was brought in, he made some very negative remarks about me and told the court that he didn't want me because I wasn't going to do the situation. And I said to the judge, well, it's a reverse onus situation. My friend, the Crown here, said that sureties come forward. The parents can't come until Monday. So the person got up and said, I don't want him anymore. So the JP put me off the record, and that person, of course, got detained and was 30 days before they could have their bail review. That was all about going to a party. So next thing, disclosure. It's a very important aspect of the matter. I was at a MTO situation there, in a motor vehicle truck situation. It had to do with the records. And of course, the Crown has to give you all of this. But there was a slip up, and the provincial prosecutor was there, now a justice of the peace. He is in the middle of the case and asking about these records. And I stood up and said, I haven't seen any records, but I had sent my letter to the Crown saying, you got anything, give it to me. You need to do that standard letter, whatever. And if you think there's stuff, maybe you should send another letter. But what happened was the MTO officer had forgotten to send this stuff to the Crown. Well, the Crown attorneys in this jurisdiction and the prosecutors are sensible for the most part, as far as I can make out. The prosecutor just stood up and said, the case is finished. There's lack of disclosure. JP dismissed the case. That was the end of it. You know, they're realistic. At least here they are. I don't know about some other places. Next, witness interviews. Keep in mind, there's no such thing as a defense witness and a Crown witness. They're a witness, and maybe they're called by the defense, and maybe they're called by the Crown, but you'd be surprised how often the Crown witnesses help the defense. So just be sure when you are interviewing witnesses, always have someone there taking notes. I always had a person take notes, and then I would have the witness read them over and sign it so that if they contradicted themselves, then I could challenge them on their contradiction. Guilty pleas before trial. for sure. It's a very important thing. I put down 85 to 90%, but Patricia has the statistics that show it's even higher than that, of guilty pleas. And the pre-trial system that came into existence was where you can negotiate this. I call them a plea agreement. I do not like the term a plea bargain. This isn't a bargaining game here. This is the Crown and the defense sitting down and talking about what is reasonable in the situation. And as I said, the Crown's office here in Kitchener is pretty much on the high level of reasonableness. One thing you've got to be careful of. A couple of years ago, Mr. Justice Hambly, on a serious matter where both the defense and Crown had put in a joint submission, and Justice Hambly chastised them because what they'd agreed upon was not really sufficient for the charge. And if you go and don't make realistic submissions, you're going to lose your reputation. You do not want to lose your reputation. The other thing on the presentation of your case, you have to prepare your client. You've got to go over 2, 3, sometimes 4 times while they give their story, so they know what their story is. Whatever you do, if the client asks you, what should I say? Don't answer that question. Do not answer that question. I've seen in court, luckily not me, but I've seen it where the person says, I forgot what the lawyer told me to say. That'll blow your case completely out of the water if you do that. Your reputation and your client's evidence will go out the window in short order. At the pre-trial conference, you have to be very careful not to disclose your defense. Do not disclose your defense. There's a few small exceptions where you have to say stuff, but for the most part, do not disclose your defense. You want to talk about a plea agreement and this and that, that's fine. But I know in a provincial offenses case I did about letting someone else drive without the insurance. I just left it to the Crown to try and prove their case because the witness was able to show that the person who was driving wasn't charged. The person who was the owner was charged. But my client was acquitted because the Crown, on that case, misinterpreted the law. The Crown thought the owner was a registered owner, but that's not what the statute says. The statute says owner, and the question of who's an owner is, of course, a question of law. And the judge found as a matter of law that my client was not the owner. On admissibility of evidence, you've got to think about the case of Brown and Dunn. That is, when you're cross-examining, you've got to put your client's issues and what your client's going to say to those witnesses. If you don't do that, you're going to get stuck with having your evidence limited because you didn't put it to the Crown witnesses. About the pretrial motions or mid-trial motions, the non-suit at the conclusion of the Crown's case. That's a very interesting proposition. If you think that they don't have a case, then make that motion. I've had more than a few cases that got thrown out because the court said there's not enough here to find anybody guilty of anything. So that's something you should look into, is motions for a non-suit. In the end, the advice that Patricia gave is right. When you're making your submissions, say, I believe my client should be found not guilty because, and then 1, 2, 3, and hope that the judge is going to buy into your side of it. Do not ramble on and then come to the conclusion. Set up what it is that you want and then justify it. Anyway, I think that Patricia said about all there is about the sentencing. About the pre-sentence report, that is something that you should consider in every case, whether it is a good idea or not. In some cases, it's very important. Anyway, that's what I have to say there, Leo. So,
thank you, Mr. Claxton. A lot of our students are wondering about your information. If I'm correct, your email is ted.claxton@trials.com.
yes.
Okay. Well, that's where you can contact Mr. Claxton if you have any questions. Okay. And a lot of you are wondering about the PowerPoint, if it is available. Patricia, would this be available to our panelists? I'm asking because of copyrights.
I created it, so that's absolutely fine.
Okay, thank you.
Okay.
I'm going to introduce our next panelist. He's Justice Roger Salhany. Roger Salhany is a retired justice of the Superior Court of Ontario, a former barrister, a Queen's Counsel, a notable distinction that not many have, and he has been lectured to judges, lawyers, law students, administrative boards, and police officers. He's the author of 7 books on criminal procedure, a handbook for trial judges, criminal evidence, cross-examination, the origin of charter rights and police investigations. His stats on Canadian criminal procedure has been continuously published and updated annually since 1968. He has been on different interviews from, he has given different interviews from the Ontario Law Society. And I would like to welcome His Justice and Your Honor to this panel. Thank you for being here, Your Honor. And please let us know how we can assist you. And let us know what's the role of the judge, what's the sentencing. A lot of us have a lot of questions regarding how judges work in our criminal law system. Go ahead, Your Honor.
Can you hear me?
Yes, we can hear you, sir.
Okay. I want to say hello to Ted, who used to appear in front of me regularly, and one of those lawyers that I could indicate very honorable. I also want to say hello to Ms. Moore. I hope you enjoy Kitchener. It's a wonderful place, and I had many, many years. I was appointed to I was called to the bar over 60 years ago, about the time that things were changing with legal aid. And then I was appointed to the bar, appointed to the judiciary 40 years ago. So I'm really an old timer. and things have changed dramatically. I listened to what Miss Moore had to say, and I agree 100% with everything she said. I lived in the courts. I was in court almost every day for 16 years. I couldn't do a real estate deal, and I used to have to hire a lawyer to do my, when I bought my first and only house. So one day I was in court, and shortly thereafter, I was sitting on the bench, and it was a very, very enlightening experience. One of the biggest problems judges have, particularly if they've been very active in the courts, is to keep their mouths shut. It's a serious problem for some, and I had that problem. So I went to our senior judge at the time, and Ted remembers him, Judge Costello, who was a marvelous and very sympathetic man. And I explained to him my problem. And he said, well, when you have problems and you want to talk and you want to take over the case and think that you could do a better job, the first thing you do is you take your right hand and put your chin under your hand and press down on the table. And it's very helpful. And so it took me a while before I got used to letting the lawyers do their job. I was very active in civil as well as criminal work during that 16 years until I eventually ended up in Kitchener. And one of the things I had to learn was how to be a judge that controls the court without saying much. And I liken it to an orchestra leader. The orchestra leader puts his hands out and he says, this is your opportunity to speak or to play, and points around to the various members of the orchestra as the case is proceeding. And I found that was a very good way of being able to conduct a trial. It's important that the judge have total and complete control over the trial, and ensure that the lawyers show respect to the various participants. In particular, it's important that the judge ensure that the witnesses are fairly treated, and that the victim is also fairly treated. In my day, judges were tough, and you went home every day feeling you'd gone through a battle until they got to recognize you as a person who was honorable and presented a fair case. And so when both Patricia, if you don't mind my calling you Patricia, and Ted expressed the importance of counsel being honorable and knowing that you can trust them, then that's extremely important. I always said that lawyers judges are prisoners of the lawyers who appear in front of them. They have to rely on those lawyers. And Ted was one of those that I could rely on, and most of the lawyers I could. But there was one incident that happened in my early days as a judge. And I hate to say it, he was a wonderful lawyer, but I could never forget it after 40 years, that he was someone that I had to be careful. What had happened, he cited a case to me, and I knew that there was another overruling case. And I put it to him, and his response was, well, I didn't think it would help me. And I said, well, you're not helping yourself by citing a case that is not the leading case on the point. The judge must ensure that there's no humor in the court. It's very easy for a judge to be a wisecracker and to use one line, and periodically think that something might be funny, but you must remember the witnesses are there. They're basically in a new forum. They can be very, very frightened. And I remember once when I was a young lawyer in Toronto, I was asked to sit in small claims. And one of the litigants was the mayor of a town. And I was frightened because I was only out of law school for 4 years and sitting as a small claims court judge. And he was much older than me. He was more frightened than I was. So the judge has to ensure that the witnesses are treated fairly. You also have to ensure that the victims are being treated fairly by the lawyers. One thing that I always insisted in my courtroom was that lawyers not walk around like they do on TV. They had to stand behind the judges or behind the lawyer's table. One lawyer said to me one day, shortly after I started to sit in Kitchener, that he could only think if he could walk around. And I said, well, how do you feel if I got up and walked around? The reporter walked around and everybody else walked around, and I never had problems with him again. It's extremely important as a judge to know the rules of evidence. And I say that because a trial is not, I object, lawyers jumping up yelling, I object, and the other lawyers intervening and saying no, and back and forth. When I ran a courtroom, if I anticipated that the lawyer was going to ask a question that I considered inadmissible or improper, I would stop him. I didn't want the witness to be to respond to something that might cause a mistrial. And so it's extremely important for the judge to know the various, know what the various rules of evidence, so that if he can anticipate that a question is improper, that he should stop the lawyer from asking those questions right away. Just jotted down a few things that I thought might be of importance. What I expect of counsel, I always expected counsel to be honest with me. I expected them to know the rules of evidence. I remember one lawyer who was extremely knowledgeable in the rules of evidence used to say to me, I object, and I'd ask why. And he'd say, well, this case says, and I said, no, why? Well, this case says, no, why? What rule are you relying on? And so it's extremely important that the lawyers understand why hearsay is not permitted. And today, hearsay has been expanded tremendously so that the lawyers are given the opportunity to admit, or at least seek the admission of evidence that satisfies necessity and reliability. But in my day, we applied the strict hearsay rules, and it was often very difficult to get in evidence that was ostensibly hearsay. So it's extremely important that the lawyers know the rules and ensure that, because the judges rely on them. Crown Counsel. One of the problems, and I'll express it to you, Patricia, is that there are many questions that come up in the Court of Appeal where lawyers, Crown prosecutors, have asked improper questions. In my book, Criminal Trial Handbook, I've listed 21. And they seem to be repetitive. They seem to be coming up frequently in the Court of Appeal. Questions such as, why do you think the complainant or the victim has charged you with this, which is not a question that is allowed. Why do you, in other words, questions that put the onus on the accused who's testifying to explain why a witness would say something. There's no onus on the accused to say anything. The accused is required to give his testimony and to be subjected to cross-examination fairly. And those kinds of questions are not fair. And it's rather unfortunate. I continue to see them. I have to read, in order to update my book, on my books, I have to read all of the Court of Appeal decisions in criminal matters in Canada. And it seems to come up with frequency. And it's unfortunate that the crowns, or some crowns, and they're usually by young crowns, who ask that sort of question. I can understand their zeal in trying to get a conviction, but it's not a very fair question to put, and it should be ruled inadmissible. And what then frequently happens, it ends up in the Court of Appeal, and the Court of Appeal chastise the Crown for asking that sort of question. Sometimes they allow the appeal, and sometimes they don't. Charter rights. There's only one charter right I want to talk about, and that's disclosure. When I started to practice law in Toronto in 1964, and I lived in the criminal courts because that was the only place where you made some money as a young lawyer, and legal aid came along shortly thereafter. There was no such thing as Crown disclosure. Bill Common, who was the Deputy Minister of Justice at the time, gave a speech and said, oh, there's no fast. We don't pull any fast ones on Defence Counsel. And I'm sure he believed that, but that's not the way it was. And in 1990, a case called Stinchcombe, written by a very brilliant lawyer and judge, and who whipped me a couple of times in Toronto, Justice Ciuffetelli, in civil cases, wrote this decision and said that the Crown has no ownership in evidence that is in the hands of the Crown to prove the guilt of the accused. And so disclosure is extremely important. It has changed the way trials are conducted. I found most Crowns in the 60s and 70s when I practiced in Toronto were very open, but some weren't. And quite often it was because they were told by police officers, I don't want the accused or his counsel to know anything that's in the Crown brief. But when I became a Crown, and I did part-time federal Crown for many years, I used to photostat the Crown brief and hand it to the lawyers. If I couldn't prove my case on the evidence I had, my position was that I would win or lose on that evidence. And if I lost, that was fine. Because and I was listening to you, or to your, I was reading your memo, Patricia, in which you said the Crown does not win and the Crown does not lose. I have a lot more to say, but I don't have much time to do it. And so thank you very much.
Thank you very much, Your Honor, and I appreciate all your input and your expertise, and we will have to answer several questions after I introduce our OPA president, George Brown. And I would like to welcome George Brown. He's the president of the Ontario Paralegal Association. He has provided support to paralegals, and he's an advocate for the paralegal profession. I would like to welcome you, George, and thank you for your time. I know you're running tight. Please provide your remarks.
Welcome to everyone to this presentation. It's the first time that the OPA has done a joint CPD session with any college, and we are doing this with Trios, and this is a great presentation. I'm sorry for not being in attendance when we started this morning, but as usual, we have these emergency that pops up in our office, and we go crazy trying to solve them. This event will not be our last one. We will have many more events like this, I hope, with other colleges as well. And I thank the great speakers this morning for giving us their input. And I'm a fan of evidence, and listening to Justice Rogers is just impressive to see how far our profession has come to understanding evidence, and knowing that if you don't understand evidence, you stand very little chance of properly representing your client in court. And we try to push this to all our members, and so this is a great event to complement some of the issues that we're pushing with our members to understand how to function once you get into the courtroom. Thank you all.
And thank you, George. We appreciate you having you here, and it's also an introduction for the attendees to for the Ontario Paralegal Association. It's such a wonderful organization that provides support to paralegals and students like me, and I appreciate all your leadership.
Yeah, I also want to compliment the bench. Over the years before the paralegal education and diplomas and graduating and getting a license from the Law Society, the bench was our teacher. Yes, we made a lot of mistakes, but the bench was essentially our teacher, and we work hard to make sure that when we appear before them, we seem as though we understand what the issues are, and present it in a way that looks like we actually put some time into it. Listening to some of the presenters today kind of bring back memories of when we would just walk in and hoping that we were ready. And the new paralegals coming out today, we commend them on having this knowledge that they can work with, because when we started, we didn't have that at all. We had to learn as we go along. So.
And let me add to George's comment. If anyone would like to become part of the Ontario Paralegal Association, please visit their website, and you could verify with me. That's OPA.com or .ca?
OPAonline.ca.
Online.ca, exactly. So you could join. They have different resources, and they right now they're going through a transformation where you could find different forms that are applicable to each court or tribunal. So in terms of that benefits a lot of our students and attendees. And then after I have said that, let me say that I would like to give thanks to our education committee and the student committee for all the support, as well as Trios College for opening doors to all the students and enhancing this education that we all need as future paralegals, and also for the paralegals out there as licensees. Right now, we're going to take different questions from our attendees, if that's okay with the panel. And George, thank you so much for attending, and thank you again for your leadership. We cannot hear you, George.
So sorry, I have to get used to that. I just want to say before I go, one of the things we've done because of the pandemic, we realized that most of the paralegal members and students are not able to have these networking abilities and meet each other and congregate and trade, opinions and ideas. And so we've created Zoom rooms across various regions in Ontario, South regions, or North region, for these groups, for these people in these regions to actually come together. We've created landlord-tenant rooms, small claims rooms, so anyone can take over a room and have a discussion on ongoing issues, new legislations, or even the court process, what is happening with the courts and how it's changing and how we must adapt to the new platform in terms of filing documents, making submissions, and even conducting trials or hearings. So these rooms are there to help people understand the changing dynamic of the legal system, and what I think will not return to the old system, that we will have some remnants of this process going forward. And so these rooms are there to help people to come together and exchange ideas.
Thank you again, George. I appreciate that. Right now, we're going to take all your questions, and Doug will be our moderator for those questions. Thank you, Doug, for joining us. And
thank you. Yes, Saida had to leave, so we're being very dynamic and going on the fly. So I'll jump in to help.
And you see the attached yoke?
Yes,
it's the same.
Yes. Yes.
So we have several questions, George. One of them was for Justice Salhany. Can you review that question? And it says, it comes from Richard Stewart. It says, where can we get Judges Salhany's book?
Can I reply? Can you hear me?
Yes, we can hear you, sir.
They're very expensive. And I say that I'm very upset about it, but the law book companies have charge a hell of a lot, and if I may use that word. You can get them in the libraries. You can't afford the books. My first edition of my criminal procedure in 1968, I had come back from graduate work, and I was trying to make a living. It would cost, I think it was $18. It's now $300. And so the best thing you can do is go to a library and zoom through it. I can't. I'm as disappointed as I'm sure you will be if you try to get those books. You might want to read my book on evidence. Ted is helping me. It's a book which I wrote in 1990 for when I was doing sabbatical at Western, and I'm trying to get it published again, and Ted is helping me with it. It's more reasonable, but it's still close to $100. So go to a law library. Some of my books are in the libraries in the various cities. I know in Kitchener, the main library has the books. Maybe even Patricia might allow a budding paralegal to borrow those books. Okay.
Yeah, Your Honor. Also, I should note that paralegals do have access to the Great Library as licensees, so that is also another resource that's available to paralegals, just as it is for the rest.
It's up to date. I add 5 times a year the latest cases, and you can find both in the trial handbook and in the procedure book, which is a textbook. It's a 2-volume textbook. Okay.
Well, I hate to say it, Your Honor, but Meg's also cut back on the number of textbooks we get. So I think we can get access online through our main library, but our library at the courthouse, all the books are quickly disintegrating because we're not allowed to replace them. But I guess it's a sign of the times.
There's another question to the panel from Vic. And Vic asks, thinking back to a time when you were in school, what are some things that you would have done differently? And so I'll just open that to the panel. Feel free to take that up.
Well, can I start?
Go ahead.
Yes. I wanted to be a lawyer from the time I was probably 6 or 7 years old, because John Matheson was a lawyer in Brockville, my hometown. And I would see him because my grandfather was the governor of the jail. And it turned out when I was going to law school, he'd been appointed as a judge in Ottawa. And I asked him to come to our criminal law seminar, which he was willing to do. But when I went to see him, I said, gosh, it's been so long since I've seen you. He says, do I know you? I said, well, I used to see you in my grandmother's kitchen. And he said, you're not little Teddy, are you? I said, no, one and the same. If you want to be in the law, you've got to be like Judge Salhany. You have to want it. You have to be it. In law school, I was on the editorial for the Ottawa Law Review. I wrote 2 articles that I had published before I even graduated. I edited the Canadian Encyclopedic Digest for the criminal or the civil rules. I read a lot. I don't know what I could say about something I do different. Just get in there and do it. If you really want it, you just have to do it.
Patricia, what did you want to do?
I was going to say that advice I often give to students is go watch court. I mean, when I went to university, I was going to be an accountant, believe it or not, and or go into business of some kind. And I did job shadowing with one of the Crowns in the London office, and I was hooked. So, you know, you think you know what you want, but it might be based on TV or your perception of it. But go get a real taste. You'll find that lawyers, judges, Crowns, people are very generous with their time, and they're happy to talk to students. They're happy to have you sit with them for a day, to shadow for a day. So that's my best advice. Go take advantage of that. Don't be afraid to ask, because you'll probably get a really positive response. And go watch court, go check out different things you might want to try out, or you think you might want to try out, and explore different opportunities, because you really don't know unless you try it out.
I wanted to be a history professor. So I, in my first year of law school at Osgoode Hall in those days, Osgoode Hall was the second school. I used to go and sit in the courthouse and watch the criminal cases and watch the civil cases. And it was amazing. There was Arthur Martin and Charlie Dubbin and J.J. Robinette. And I was amazed how they handled the court system, how they conducted themselves, and how the judges, who in those days were very nasty judges, they handled the judges by being patient with the judges. And one day I said, well, you know, this is what I want to do. And that's why when I was called to the bar, I decided I wanted to do just trial work.
Thank you, Your Honor. And what input Aristides has regarding the question that our students provided?
I'm sorry, I didn't get that. Oh, sorry.
That's okay. Aristides, please. What question? How would you answer their question? What would you say in front of our students? What kind of advice would you give them regarding the time that you were in school?
Perfecto. Yo le recomendaría a los estudiantes de derecho o de abogacía una dedicación exclusiva, especialmente a la lectura, a conocer el problema social, la sociología, profundizar en la filosofía del derecho e ir a los estrados judiciales a escuchar las intervenciones de los abogados, bien sea de la fiscalía, de la defensa y la majestad de la justicia a través del juez. Hay dos personajes centrales en el derecho penal que son el acusado y el juez.
Alexander, could you please translate that?
Además,
Hold it, espérate, Aristides.
Perfecto.
Well, I would like to recommend the students that they have to read a lot, to learn from social studies, to learn philosophy, and to learn how to listen all the spaces in the court. That means the judges, the crown, and of course the defendants. And at the same time, it's necessary to learn how to order so many ideals that we have as a lawyers. And he's going to continue.
And we have a question, Aristides. The question is, can you please tell us how Canada's criminal system is viewed from the rest of the world?
La justicia colombiana, en mi criterio, no existe la igualdad y para mí se maneja de acuerdo a la posición social del acusado.
In this case, we're talking about Canada's criminal system. En este caso, estamos hablando del sistema criminal de Canadá. ¿Cómo es visto?
Perfecto. La justicia canadiense, de acuerdo a las experiencias en mis lecturas y lo que he escuchado de este panel tan interesante, donde felicito a cada uno de los que han intervenido, raya dentro de lo que se busca o hay que tratar de hacer en un aparato judicial que no se desgaste. Por ejemplo, escuchaba a la doctora Patricia Mori cuando nos informa de un 95% de aceptación de cargos de los procesados o acusados.
Okay, can you please?
Es un aparato judicial que no se desgasta.
What Mr. Aristides is saying is that the Canadian accusatory system is quite well interesting because it follows a very good system of equality system, not like in Colombia. He was saying before the question that the Colombian system is not as equal because sometimes money can buy judges and can buy fiscales. At the same time, he is recognizing that the 95%, as Patricia more just seated, is a very nice person that we don't have here in Colombia. We have too much delay in the situation of development to trial, and we have, for example, killing too many judges on the way, or even fiscales on the way.
Para redondear la idea, en Colombia el 95%, o diría que el 90%, llegan hasta juicio los casos. O sea que hay un desgaste grandísimo del aparato judicial del Estado. Y dado nuestra problemática social, por la miseria, la desolación, la desocupación, el desempleo, la delincuencia es muy alta, a diferencia de los países desarrollados como el Canadá y otros.
Aristides, okay, that means that 95% that Patricia Moore put us on a quote, we have 95% of trials in Colombia. And that is because we have too many situations like drugs, cartels, guerrillas. We have unemployment rates very high. We have the pandemic problem rise as well. So there is not a good justice system that we can afford here. So that's the way it is.
Ya quiero terminar. ¿Me escuchan?
Sí.
Quiero terminar diciendo que estudié Derecho porque desde mi infancia vi las miserias, la desolación, el poco acceso a la educación, al trabajo de la mayoría de nuestra población. Y recordaba a un autor que se llama Francesco Carneluti, que habla de las miserias del proceso penal. Y por ello traté de reivindicar los valores humanos de las personas más al margen dentro de nuestra sociedad.
So I started studying law because I feel the necessity to help the country because of the poorness, the situation of iniquity, and situations that touched my heart following Carmeluti Francesco, who wrote a book about that situation. So thank you very much.
Thank you. Gracias.
Thank you for your input, Aristides, and thank you for all our panelists for answering questions. We'll take the last few questions if you don't mind, and the next question will be for our panelist Patricia Moore. Okay. So our the question goes, what effect has the pandemic had on individual rights? And do you not think that the charter become an ancient relic?
The pandemic has had a huge impact on the criminal justice system. I would say both bad and good. I mean, the good impact it's had is we probably moved the technology into the 21st century. So given the availability of technology, the court system was very much a still pen and paper type of system. And we were moving there at a glacial pace. But the pandemic forced the criminal justice system to accelerate and to move to like Zoom platforms and e-documents and things of that nature. So I think that has opened up some opportunities and some equality. But one of the things we've been discussing is access to justice. So for those people who don't have computers and they don't have unlimited internet, and they don't have those technologies or that space, it's a real concern. And we've been working with our community partners, with Kitchener Public Library, has been providing a computer terminal and availability there for people to attend. But literally, we have our courtroom doors for case management court are still locked, and people come to the courtroom because they don't have a phone or they don't have a computer, and they take the initiative to show up, and they don't have those means. So it's a discussion, it's a concern, it's something we're very much have identified and are working towards. But for the people that don't have the benefit of technology right now during the pandemic, they very much are at a disadvantage. So we're still running in-person trials, just so that people are aware that, especially in the Ontario Court of Justice, we're still running a lot of in-person trials. But for other matters like case management court, that is remote, and we've been struggling to find ways to provide access to justice to those people. So that was the first question. The Charter of Rights and Freedoms, I don't think it will become ancient, because it very much continues to be interpreted by judges, and it's interpreted based on current societal norms. Even the Supreme Court of Canada, they have revisited decisions that were made, 10 or 15 or 20 years ago on privacy rights and what is a reasonable expectation of privacy. That's a really big area that is constantly evolving. It's frankly hard to keep up as to where the line is right now, because it's always changing. So I don't think it will become antiquated, because it's continually being reinterpreted based on our current societal norms.
Thank you, Patricia. And one last question, and to close this event, and this will be directed to the remaining panelists, would be, can you share the most satisfying moment in the courtroom and the circumstances that led to that experience? Any of the panelists would like to share? Ted, Aristides, or Your Honor? Roger?
Well, it was the time I won my first case. And it was an unusual case. I was just out of law school in the days of legal aid, and I got a call from the Don jail, and I went over and I spoke to a gentleman who was charged with fraud. And I had to explain to him that this was my first criminal case, and I didn't really know how to do it very well. And he looked at me and he said, "Don't worry, kid, I'll carry you." And he did. And he told me what questions to ask and what questions not to ask. And he was acquitted. And it was, he had a terrible record of fraud. And he called me, he was acquitted, and about a month later, he called me back and said, "I've been charged again." And I said, "Yes, thank you very much, goodbye." But it was a very uplifting moment, because for the first time, I felt that I could succeed. And that's, for young lawyers, it must be very frightening. I did so many cases, maybe over 300-400 cases in my 16 years. And so this was the first, and it gave me some encouragement, and I lost my fair share, but that's okay.
Thank you. Thank you, Your Honor, for sharing that experience. What about Ted, Aristides? Do you have any rewarding experience that you would like to share?
The best experience that I had ended up in the Court of Appeal. The Crown, when the Young Offenders Act came in, they couldn't charge young offenders with breach of probation anymore. And what happened was there's a little gap there, because my client was an adult when he got the sentence. He was 16, And then, of course, they raised it up to 18. So they tried to, they couldn't charge him with a breach of probation. So they went under a section of the criminal code that's numbers changed now, but it had to do with disobeying a court order for which there was a 2-year sentence. Whereas in the breach of probation had a 6-month maximum sentence. And Judge Colin Westman, he agreed with me, and so the Crown took an appeal. And that's a case I think I won in my paperwork. Court, the Crown came in, and I think it must have been a inexperienced Crown, because they started reading their factum, and Justice Dubbin was on the bench then, was the Chief Justice, said, we've read your factum, please give us your submissions, which completely threw the person off. And then at the end of that, they took a break and they came back in, and I stood up and they said, we needn't hear from you, and gave judgment agreeing with Justice, or Judge, I should say, Provincial Judge Westman. And so that was based on the question that there was no legal basis for what they were doing, and the court agreed with that. So that's what I think was the most satisfying case I ever did.
Thank you for sharing your experience. That we appreciate your knowledge and all the experiences that you have lived, and that will pass on into our students. What about you, Aristides? Can you tell us your most rewarding moment?
Gracias. He tenido en mi trayectoria como abogado defensor por más de 35 años muchas defensas, pero hay una que me llena de mucha satisfacción, y es demostrar en un proceso penal que no se trataba de un homicidio, sino de un suicidio. Y la persona estuvo judicializada como si hubiera sido autora material de un homicidio, pero a través de las evidencias o las pruebas demostré que no era un homicidio, sino un suicidio, y el juez absolvió.
What he's saying is that after 35 years of practicing the law, he got a case where the person was in jail because his condemnation was about homicide, but when he tried to defend him, he proved that was suicide. So that was the best moment of his life when he was doing defenses.
Para ese caso, me tocó asesorarme de la psiquiatría forense, ahondar mucho en la psiquiatría, especialmente la conducta de los suicidas antes del hecho, cómo manipulan o llevan a su mente esa situación antes de llegar al suicidio. Y eso me ayudó para salir avante y demostrar la verdad en el asunto donde se iba a condenar a una persona por homicidio y se demostró que fue un suicidio. Una satisfacción muy grande porque la pena del homicidio es supremamente alta.
I have to use for this specific case psychology that helped me to understand the human conduct. So in this case, that helped me a lot, not only by the times of experience, but I may able to prove that he was innocent, and that helped me a lot. And thanks to the life that I learned through that.
Thank you. Muchas gracias.
You're welcome, Aristides, and thank you for sharing that. I know something that I might have missed in the translation was that through exhibits and evidence, you were able to prove that that person was innocent, and you mentioned that homicide has a greater penalty than suicide. So that's something different, and everything relates in the conduct before the action took place, and you mentioned that. Well, I would like to thank you all. I wanted to be really fair with all the questions for the panelists, and I would like to provide the final remarks. Thank you to all the attendees. On behalf of Trials College and OPA, I would like to thank you for your attendance. And Doug, you have some final remarks on behalf of OPA, I believe.
Yeah, I just want to thank everybody. And as you can imagine, with all these moving parts and technology, this is actually a common occurrence. And our members experience this every day when they're trying to attend courts, some of which are not open yet. And the same challenges are being faced by everybody in the industry. So we're now expected to be Zoom experts here in Ontario. So I just want to apologize on behalf of our technical issues. Thank all of the panelists for taking the time out of their very busy professional days to spend time. It's been very informative. We very much appreciate it. And for those students that are listening, Leo is a perfect example of the kinds of initiatives that students can lead in this area, in the educational area. And I would encourage all students to follow his lead, really, and step forward and get engaged and get involved in the community. This is the best form of education there is, at least in my humble opinion, as a new licensee, fairly new. I've been licensed since 2016, and as Patricia alluded to, the best way is really to learn from examples. So I would encourage all students to get out and make themselves available and find a really good mentor to partner up with. And just to wrap, there is a post CPD survey. So if you could all please kindly take a few minutes to complete that, it will certainly help us in delivering future programming. And we look forward to working again with Trios in the future. And again, want to thank everybody, all the panelists and Leo and all the audience members for tuning in and for your patience today. Take care, everyone, and stay safe.